All right, so here we are, UGC under Canadian law, and this is the panel, of course, where we begin to figure it all out. I know it's going to be perhaps hard to top the morning fun, inspirational session, but we'll do our best because we're going to get into the nitty-gritty, the legal aspects of the UGC, and I'm proud to say that I'm with expert company. We have, of course, Professor Taubman back on duty. We're getting our money's worth from you as the Genet Global faculty. On his right, he's joined by Professor Sam Trusso, University of Western, who's done a lot of work in this area. And Leonard Glickman, partner at Castles, of course, one of our founding supporting law firms. So we'll start with the broader brushstrokes, and here I think quite appropriately, because Professor Taubman is also an artiste, that went unmentioned in today's introductory remarks on you, and if you want to see some samples of his work, you should check out the Common Law of IP, where we dedicated to Professor Weber, and he has the cover page art on that. So he is going to draw the broader brushstrokes. Then Professor Trusso will infuse the color by looking at the interactions of the UGC with fair dealing, and Mr. Glickman will finish with some of the contours, looking at the interaction of UGC and trademarks. So why don't we kick things off up to a maximum of 15 minutes so that we have time for discussion, and I need us to get caught up here, so I'll be watchful of the clock. Okay, Professor Taubman.
Mina, thank you very much. I had two versions for this presentation, one which was longer and one which was shorter, but I think I'm going to choose the third version, which is the even shorter one, bearing in mind that we're running very short and that the discussions are extremely interesting. So I will really focus on some pinpoints, main points, and leave the rest to the participants to state their views. First of all, perhaps one should say a few words about what is meant by user-generated work or user-generated content. I mean, very simply so, it's using a work as raw material to create one owns work. If you look, and you have in the small kit that was distributed to you, if you look at section 29.21 of the new Canadian Copyright Act, you would see those elements flushed out in the, it is not really a definition, but at the same time it is a description of what the UGC consists of. First of all, it says to use an existing work, that's the first element. So whoever is being shielded by the exception has used an existing work. And second, end of the second sentence, in the creation of a new work, so he has appropriated it, so to say, or integrated it to the creation of a work of his own. And third element, which is at the bottom of line 4, and to use the new work, so this is not only has she integrated it to his or her own creation, but she has used it subsequently. And one has to understand that the kind of use that has been done is a use that would be covered by copyright rights. Okay. Either she has used it or authorized an intermediary to disseminate it. So the use could consist very well of reproduction, and we have seen ample examples of this this morning. It consists of public performance, what takes place in the discotheque, for example. David has amply demonstrated it. It consists also of communication to the public through broadcasting or by otherwise through, for example, websites such as YouTube, etc., etc. So this is as far as the concept is concerned. The fields to which this very broad concept apply consist of what I would qualify as a vast spectrum of activities Of course, there is mashup and reuse. I won't get back to it. Appropriation, but the list is endless, so to say, and it could include video games, fan fiction. Marian Hab is going to tell us something about it this later on. And last but not least, parodies. And I would dare say that perhaps parodies are the field where UGC has the most flourished and where success has been sometimes phenomenal. The figures sometimes are really staggering. Suffice it, for example, to refer to the famous video Gangnam Style of the South Korean singer Psy. I'm sure that all of you know what I'm talking about. It seems that it would have already reached the number of 1,781,000,000 hits. This is like breaking all records in this domain. But wait a minute, there is even more to it. As President Reagan used to say, you ain't seen nothing yet, so you ain't heard nothing yet. The video, and this is the most important part, has been played, imitated by thousands of imitators. The figures that I've got are kind of conflicting. They run from 10,000, which is quite a respectable figure, to 33,000. That means one piece of music, one song, up to 33,000 user-generated contents that this song has generated. And what about the latest success? I don't know whether you've all heard of you. The Fox, played by two Norwegian comedians. Can we play a small extract of it? Only 1 minute. Okay, this is only an extract, and you can imagine the immense success that it is having, and all kind of imitations, ramping on the net. Okay, which leads us to the question, why the success of UGC, and what has contributed to the birth of this new kind of works called UGC? Well, with the advent of digital technology, I would say that the relationship between the user and the work are not the same as before. Under the analog world, the user mainly was a consumer. He would read, listen, look at, enjoy, period. In other words, he would have like a passive role with regard to the work, what I would call distanciation. It could happen that from time to time he would or she would intervene on the work, bring modifications, translate, adapt, transformation, but this would necessitate investment in time and investment in money. That's why, as a result, it was not that frequent, and the transformation were made usually in the context of professional activities. Now, what's happening with the internet and in the digital field? Well, nowadays, with a minimum amount of time and effort, individuals can interact with the original work. Very often these activities are conducted for the fun. They do not necessitate big investments nor a big amount of time. They are conducted by the fun by amateurs without any commercial or professional target in mind. But on the other hand, some do use them for professional purposes, like appropriation art, or what David, I thought you were Gordon, or what David explained. He is using it, for example, in discotheques and so on and so forth. In any case, whether the use is made for fun or for professional reasons, in most cases the incorporation of a work, someone else's work, on one work that one has created generally constitute an infringement. There is a sizable number of cases where the caking could be considered as a substantial part. So I have 5 minutes and I barely started exactly the topic. So that's why the Canadian legislator thought that some exception should be carved out in order to shield from violation some types of activity which otherwise would have constituted a violation or infringement under certain conditions. So which are the activities protected? You have a piece of paper where the section 2921 has been reproduced. So it's very clear, as we specified, it's the use of an existing work. Yeah. The integration of this existing work of another work, and the reuse, the subsequent use of the work. Who are the beneficiaries of the exemption? And this is something very interesting. First of all, it is the individual who made the original use and who presumably has reused it later on. But then, in a kind of a quite surprising way of stating things, the Act also applies to members of the household, if authorized by the initial user. I wouldn't say that this is a monument of clarity, the way of expressing itself. It could mean, and I looked at the dictionary, it could mean any person living under the same roof, be them members of family or not, or to a social unit composed of living together in the same dwelling, for example, a commune or student sharing an apartment. I find it quite far-fetching. I mean, to the extent that someone has used the work initially, integrated to his own or her own work, and use it subsequently appears to me like normal. To the extent that children living in the same house has done the same, being authorized by the mommy or the pappy, it's also perfectly comprehensible, but I find that the exception is extremely far-fetching and could apply to adults who had nothing to do with the initial operation of using or integrating the initial work to their own doing. Okay. The activities that are covered by the work, we stated this already, the initial use of the work, its integration to a new work, and any subsequent use. These are all activities conducted by the user. But also the Act also hints to the authorization of an intermediary to disseminate. So those are acts which are conducted by YouTube or other ISPs, That means being able to upload it on internet and to communicate it further to the public. What are the conditions to which this exception is submitted? Very quickly so, because we have little time, and I'm sure that I have already used my 5 minutes, but I'll try to make it as short as possible. First of all, under 2921B, the source has to be mentioned. So if it is an extract of a film, the name of the film has to be mentioned. If it's an extract of a book, the name of the book, and not only the source, but the name of the author, performer, maker, or broadcaster. I fail to understand why this is put here, because the infringement action might be launched by the copyright owner. The copyright owner is the producer of the sound recording or the producer of the cinematographic work. So what has this got to do with his own rights? These rights have to deal with moral rights, not with economic rights. And we're talking about an infringement of copyright and not an infringement of moral rights in the chapeau of 2921. So I find it quite odd to proceed that way. The second condition is that it has to be done solely for non-commercial purposes. This issue has been quite discussed at length a few minutes ago. I'm being told that this is the end. Could I benefit from one more minute just in order to supply the needed information so that the discussion can take place with all the elements at hand? For commercial purposes, whose commercial purposes? Is it the user or is it the commercial purposes of the disseminator later on? I think, and it's clearly stated from the Act, that it is the commercial purposes of the user, and commercial purposes is not defined, so it might give rise to lots of difficulties later on. I guess, and I'm venturing with one line of interpretation, that it is meant to apply to no direct commercial gain or no remuneration to be paid out of this type of use. I'm not going to talk about YouTube. I mean, we are running short of time. And the third element is that and this is like the cherry on the, how do you say, on the la cerise on the sundae, okay? It is subsection D, which is written in extremely difficult terms to interpret, and which probably would give rise in the future to lots of law actions. The use or the authorization to disseminate the new work does not have a substantial adverse effect. It reminds a little bit of one of the elements of foredealing, where it is about adverse effect. But here it says a substantial adverse effect. Financial fine, one can imagine what financial is, or otherwise, what does this word exactly cover? I mean, one could come up with different interpretations, but for lack of time, I'm not going to get into this. On the exploitation or potential exploitation of the existing work. Now, how this section is going to be interpreted, it is an exception, and the Supreme Court has come up with a few decisions to the effect that exceptions have to be interpreted not in a restrictive way, but in a large and liberal way in favor of the beneficiary of the exception. So it may be that this section receives a large interpretation. On the other hand, the purpose of this section here was mainly to protect the interests of the right holders. So I'm wondering whether this line of interpretation that has been put forth by the Supreme Court could apply to subsection D. I'm just asking questions, and I'm sure that in conclusions, I see a big smile on your face. In conclusion, the two conditions, C and D, may have, depending on the interpretation that the courts will give this section, restrict considerably the scope of the exception. But again, it all depends on the interpretation. However, one wonder whether the new fair dealing exceptions would not offer some kind of solace for UGC practitioners, to the extent that it extends the new fair dealing provisions to the ambit of parody or satire. Already, the Supreme Court has given the word research a kind of broad interpretation. So I am sure that it would be extremely interesting now to compare the way the factors related to fair dealing would apply by comparison to the C and D in section 2921. I'm sure that Professor Trusso will have some very interesting things to tell us about on this matter.
Yeah.
And hence,
Can I go up to the podium?
Yep.
So my name is Sam Trusso, and I'm an associate professor at the University of Western Ontario in London, Ontario, where I hold a joint appointment in the Faculty of Information and Media Studies and in the Faculty of Law. And if I look down to my notes, I'm going to just lower this a little bit. So I think that when we have a discussion about fair dealing and its interaction with the user-generated content exception, it's really important that we not do it just in isolation, just looking at the legal text. I think we need to back up, and we need to ask a very, very fundamental question here, and that is this development of user-generated content a good thing that we want to encourage? Is it a bad thing that we want to regulate? Is it just a neutral thing that will tolerate up to a point, but we don't want to really nurture? And my position on this, having worked on some research projects outside of the law on user-generated content, is that this is a very important development. This is perhaps the most significant development in the field of digital content in the past decade, and it's a game changer. And it has the ability to do some very socially beneficial things. So I think before we even get into a debate about how far user rights should be with respect to the stock of copyrighted works, we have to ask ourselves a policy question, and that is, do we want to encourage this? And the reason why I think this is appropriate in legal analysis is we are in a utilitarian, sort of a balancing-based copyright regime right now. And I know that that's something that is very, very difficult for some people to grapple with. But the fact of the matter is, while it's not entrenched like it is in the United States Constitution, we have a very, very clear set of not just case law, but also now statutory language in the preamble to the Copyright Act that makes it very clear that we are balancing social values. So what user-generated content does is it allows direct citizen, direct people-to-people involvement outside of the traditional corporate structure. 30% of the world's population has internet access. 500% increase since 2001. In developing countries alone, 25% of the people have home computers, 20% of the people have home computers with internet access. And most significantly, in terms of looking towards the future, for people under 25 years, this accounts for 45% of internet users worldwide. So we have to be willing to break from the ideology and the business models and the way of doing things in the past if we want to move forward to this. And by the way, everything I just said I think would be relevant to a fair dealing analysis. Now, in addition to internet connections as a basic enabling device, you have to have access to content creation devices, you need to have access to tools, and you also need to have access to raw materials. In one of my previous works, we talk about the classification of user-generated content. I'm going to skip over that in the interest of time. What I want to underline, though, is that user-generated content is a disruptive historical force. Yes, it is. And I understand quite well why there are many people who are very upset, concerned, not happy with the direction that this discussion is taking. But times are changing, the technology is changing, the ability of people from all walks of life to interact with technology, maybe not at the level of what Dan Rosen is able to do, but that sort of thing is going on at a very primitive level in basements and garages throughout Canada. And the question is that a good thing or not a good thing? So on the one hand, the paradox of user-generated content. Copyright restrictions threaten to impede creators' engagement with user-generated content. This is aggravated. This possible impediment is aggravated by the imposition of TPMs. It's also aggravated by, not applicable in Canada, but it doesn't really much matter if you try posting something to an international website like YouTube, the takedown rules. And also, I think within the context of the schools and the universities, unfortunately, and this is something that's more within our control, we're operating under some very, very restrictive and unhelpful institutional guidelines. And I'm not going to develop that. That's a whole nother talk. Now, on the other hand, creative practices informally evolve. They informally evolve. Nevertheless, despite all of these restrictions, informal creative practices evolve. And when these informal practices become widespread, they drive reform in the law. Here's an example of an informal practice that became widespread, that probably technically was not within fair dealing. Taping television shows. Was that research, private study, criticism, review, news reporting? Well, if it wasn't, technically it was illegal. And I suspect a lot of people who are policymakers and community leaders have VCR devices in their house, or whatever they're called now. And finally, in 2012, Parliament sees fit to sort of like, well, you know, people are sort of doing this anyway, and my kid's doing it, and I do it, so let's just put it in the law. So these informal practices are very important. Now, this paradox is embodied in Bill C-11, which on the one hand implements these DMCA-style rules, digital lock rules, but on the other hand creates important new, or at least attempts to create important new user rights, keeping with really the development of digital technology. So the other thing that user-generated content does is it breaks down these historical established dichotomies. And these dichotomies are essential for current business models to operate. The dichotomy between creator and end user, which in the offline world is harder to get by. The dichotomy between producer and consumer. The dichotomy between performer and audience. And the dichotomy between wage work time and unpaid leisure time. It's all breaking down. Now, I think Victor did a good job running us through 2921. Let's just say at the beginning, there are enabling provisions, which are very broad, and they are followed by limiting provisions. So the thing I'll highlight about the enabling provisions is we're not just limited to works. We're within sound recordings and performances too. This has profound implications for the ability of people like Dan and his colleagues and those who want to use sound recordings to be able to operate in Canada. Now, of course, we have the non-commercial issue, which I'll discuss. But we're not limited to works, and we're not limited to the reproduction right. The only two rights that are carved out are the authorization right and the first publication right. So once somebody puts something into the cultural consciousness, you have certain enabling rights under this section. Now, the limiting conditions, that it be published, that there be attribution, that you believe the source not to be infringing, these I think are fine and can be dealt with. It's not a hard and fast attribution requirement like 2921 and like 29.1 and 29.2. It's more flexible. But I think the problems, as Victor pointed out, are the solely for non-commercial purposes. What's that mean? And then, of course, the last one. Now, solely for non-commercial purposes tries to create this bright line distinction between commercial and non-commercial, and I'm not sure you can do that. And the bigger problem is what happens when it shifts over time. So what starts out as non-commercial, a hobby or a school project or, you know, Justin Bieber trying to do a, you know, something in his basement with equipment. What happens when at some point it becomes commercial? And most certainly when something becomes really wildly, you know, effective commercially, there has to be some type of allocation mechanism. And I think the challenge is, rather than beating us over the head about, well, you know, this is property and you're messing with somebody's property, we should be trying to think of creative ways to figure out how to sort of allocate that surplus when it happens after the fact. However, we need to not just tolerate, but we need to encourage, we need to nurture the initial act of creating. And so long as people feel the copyright chill, as Edward Lee talks about, it's going to, or as Wendy Seltzer writes about, it's going to inhibit that. Now, fair dealing is additive. Thank you. You don't have to choose between fair dealing or going under 2921. They work together, and this is a good thing. Because if you fall out of one of these categories, you still can make your claim under fair dealing. Now, fair dealing does not require, as an essential element, transformativity. The user-generated content exception does. So if what you're doing is not transformative, you don't even meet the enabling provisions. You can't just sort of like have your cat sit in front of the television and videotape reruns of your favorite show and say, oh, this is my favorite episode of the Lucy Show, and this is user-generated content. I mean, you need to do something a little more transformative. Now, whether it rises to the extreme level of originality that Dan Rosen was showing us, or you know, that we've seen in other examples, is another question. However, if it's not transformative, you're not in 2921. So where I want to go with the rest of my time is, I'm going to assume there's originality, I'm going to assume there's transformativity, but what happens if you fall out of one of the sections? You get a little bit of commerciality. Now, under fair dealing does not preclude commercial uses, as we know from the CCH case, because who was the end user there? It was law firms, you know, who presumably were engaged in commercial activity. So we have to look at 2921 and 29 together. I think that the Parliament meant right. They meant to do the right thing. They meant to encourage this sort of new wave of creativity, but there were some drafting problems, nothing we can't live with. However, a better approach in my mind would be to consider this as part of fair dealing, which I think Parliament sort of wanted to do, which is evidenced by the number 29 in front of 2921, but they weren't sure whether they wanted to make a standalone exception or fold it into fair dealing. I would prefer to see transformativity recognized on the face of Section 29, or better yet, just include two words, such as, come on, such as. We pretty much have that. We pretty much have that already. So I think in closing, I want to emphasize that when we do interpretation of what's infringing and what's not infringing in terms of exceptions, limitations, and above all, users' rights, which is what they are, we need to sort of back off and take a societal view of what the benefits are of user-generated content. Creating an environment where user-generated content creators are enabled and encouraged, not just tolerated, but encouraged, to produce, distribute, and reuse new materials continues to present a challenge to policymakers. No doubt this section will be given a lot of discussion when the 5-year review comes up. Given the benefits of user-generated content, it is not enough that they merely be tolerated. They need to be encouraged. While the addition of Section 2921 to the Copyright Act is a very positive step forward, strategies for encouraging the development of user-generated content need to be more broadly considered as an essential element of Canada's innovation policy, which as yet is a policy which remains unarticulated.
Thank you. Those are, can you guys hear me? So. 2 hard acts to follow. So you have the private practitioner following on the heels of 2 eminent professors. I'll give it my best shot. There's some other practitioners here, so I'm fighting the fight for the private practitioners today. Before we start, a couple of things. I'd like to thank and acknowledge Stephen Henderson of our office, one of our articling students who helped put this deck together for me. Stephen's right over there. Stand up and take a bow. Stephen, thank you. And it's entirely appropriate, given this is a UGC conference, that a lot of people are using the conference hashtag. And I'm following on Twitter, and good to see a whole bunch of people commenting live. So I want to acknowledge Adam Jacobs and Ruth C. and Jennifer Peters and Jason and Krista Jensen and Shift Law. There's some interesting commentary happening on Twitter. So if you're online, you should check out some of the commentary. We're going to switch gears and talk about trademarks. Obviously, the focus of this day conference is copyright law, but there are some interesting issues percolating in the world of trademarks and brands that relate to UGC. So I want to, oh great. Right, so thank you. So I want to take you through some of those. There could be an entire day on this topic on trademarks in UGC, so this is your 10 or 15 minute summary of the issues, and I'm going to go through the deck pretty quickly. Happy afterwards or at some point to take any questions or discuss any of these issues with you. Oh, got to go the other way. We'll go. So we've talked about the UGC exception under the Copyright Act. There's no UGC exception under the Canadian Trademark Act that's similar to Section 2921. So whether your rights as a brand owner or a trademark holder have been violated by UGC, there's not a section you can pull out of the act and interpret it and slice it and dice it and decide whether your rights have been infringed or not. You have to look at the existing provisions of the Trademarks Act and some of the cases. So to lay the context, I just want to quickly take you through the basic provisions that are relevant in terms of UGC analysis. And the first one is the very basic, what is a trademark? So here's your definition. Trademark means a mark that is used by a person for the purpose of distinguishing or so as to distinguish wares or services manufactured, sold, leased, or performed by him from those manufactured, sold, leased, hired, or performed by others. That's the core definition of a trademark. I see Professor Vaver smiling, and I'm sort of intimidated to be giving a trademark presentation in front of, the god of trademarks. And so there are different types of marks. There's that mark. There's a certification mark, which is basically, it's a special mark used to identify goods or services that are of a defined standard with respect to, among other things, the character or quality of the goods or services and the conditions under which the goods can be produced or the services can be performed. And some examples of those are the CSA standard, the CAA automotive logo, that Wi-Fi logo you see everywhere is a certification mark. A distinguishing guise, which is basically trade dress. So trade dress can be registered as a distinguishing guise under the Trademarks Act, and it's defined as the shaping of wares or their containers or a mode of wrapping or packaging wares. And then finally, a proposed trademark. So the difference between A and D, you can file a trademark application in Canada on a prior use basis or on a proposed use basis. So D covers off marks that are filed on a proposed use basis. Let's talk about the definition of use. This is very important. So I'll read these. A trademark is deemed to be used in association with wares if at the time of the transfer of the property in or possession of the wares in the normal course of trade, it is marked on the wares themselves. I'll stop there. Essentially, for there to be use of a trademark, there has to be a commercial context. There has to be a sale transaction or other transaction. So that, transfer of the property in or possession of the wares is just sort of trademark speak for someone undertaking a commercial transaction, buying a piece of branded apparel in a store. That's a trademark. So that's important. We're going to come back to it. The commercial sort of context around what use of a trademark is in association with wares. Then part 2 of the definition of use says a trademark is deemed to be used in association with services if it is used or displayed in the performance or advertising of those services. So with respect to services, use can be triggered only by advertising. So not necessarily only performance or rendering of services, advertising of services triggers use. Here are the rights conferred by registration. Essentially, if you register a trademark, that gives you the exclusive right to the use throughout Canada of the trademark in respect of those wares or services. That distinguishes from common law use of a mark. So if you're using a trademark without the benefit of a registration, you only have common law rights in the mark, which only occur in the areas in which you're carrying on business. So if you're a Toronto-based business with a Toronto-based clientele and you're using a trademark, you might, and you have no other presence outside of that market, your rights are limited to Toronto, Ontario. You might have, if you have a website, maybe you can argue it's broader, but then if someone in Vancouver, if you're a retailer, opens up a store with the exact same name, you'd have a harder time enforcing your rights against that person in the absence of a trademark registration because your common law rights might not assist you. Let's talk about infringement. So if someone's trademark is used in a piece of UGC, so the relevant section is 21. The right of the owner of a registered trademark to its exclusive use shall be deemed to be infringed by a person not entitled to its use under this Act who sells, distributes, or advertises wares or services in association with a confusing trademark or trade name. Okay? So you could argue that non-commercial, so UGC, that doesn't use the wares or services, doesn't sell, distribute, or advertise wares or services, that UGC would not constitute use under the Trademarks Act and therefore would not constitute infringement. So the cases, there are many cases out there, the Michelin case and others, have basically said to use a mark as a trademark, that the person who used the mark on the goods or in connection with the services must have intended the marks to indicate the origin of the goods or services. And that's not often the case with UGC. So if you can't have a claim for infringement under Section 20, what else could we try? Well, let's look at Section 22, the depreciation of goodwill. If someone's using your brand in a mashup or in some appropriation art in a way that you don't like, can you do anything under 22, which says no person shall use a trademark registered by another person in a manner that is likely to have the effect of depreciating the value of the goodwill attaching thereto? The key there is no person shall use. So, so the question is there use? Is that commercial use? I think you have an uphill battle on that one. And here again, the cases have generally required commercial activity on the site or by that party to support a Section 22 claim. So as I said, sort of summarizing, Section 20 requires the sale, distribution, or advertisement of goods and services to establish infringement. Section 22 requires use to find depreciation of goodwill. And the wording means, the wording of these provisions mean that if the UGC does not have a commercial purpose, it is unlikely to infringe the trademark rights of owners or support a claim of depreciation of goodwill. Thus, it's very interesting, for practical purposes, there is some symmetry between the treatment of non-commercial UGC under the Copyright Act and the Trademarks Act, even in the absence of a specific provision relating to UGC in the Trademarks Act. So let's talk about some of the trademark issues triggered by the UGC. We've seen some great UGCs, some mashups, some appropriation art. There's all kinds of examples, and very creative. Some of the UGC out there is not as creative, not so creative, but still triggers copyright and trademark issues. And I should make the point that a trademark can also be a copyright. So for example, any brand will have just, Coke. The word Coke is just a trademark, but there's the Coca-Cola logo, which is a copyrighted visual work. So if someone is using a branded logo in UGC, they will be able to avail themselves not only of the provision of the Trademarks Act, but the UGC exception under the Copyright Act. So I've got 5 minutes, and I'm going to really breeze pretty quickly through this. So I'm going to give you examples of, just 4 specific examples of how trademark issues have been triggered by different kinds of UGC, and I use that term broadly, essentially any content created or posted by users. So the first one is going to deal with the posting of ads selling counterfeit goods on classified ad and auction sites. That's a user basically creating an ad, putting it up on a site, and using a trademark. So here, trademark owners are concerned by the availability of counterfeit goods bearing their marks on sites which allow such items to be sold, such as eBay, Amazon, Kijiji, Craigslist. So they're constantly monitoring those sites. People typically think of counterfeit luxury goods or sports apparel, but trademarks can be used on all manner of counterfeit goods. I think this is a Louis Vuitton bag, right? Stephen, is it a knockoff bag or a real one? Knockoff? We don't know. There have been a lot of cases on this point. One of the big ones is Tiffany and eBay. Tiffany has really taken an objection to their counterfeited goods being sold on eBay and other sites, and they've started lawsuits all over the world. In the US, they have essentially not been successful. There have been actually some decisions in Europe going the other way, but in the US case, the court, there's counterfeit Tiffany goods being sold. There, the court found no primary infringement as eBay's use was lawful. It was really using the mark to accurately describe the genuine Tiffany products on its site, and it was taking down when Tiffany was complaining, they were taking down the counterfeit goods and listings. The court found no contributory infringement on the part of eBay, rejected the claim of dilution by Tiffany, as eBay did not use the Tiffany trademark to create an association with its product, but rather to advertise the authentic merchandise available on the website. So that's a flavor of the cases. In Canada, let me go back. Right, so in Canada, we are known as a relatively toothless jurisdiction when it comes to fighting counterfeit goods. We're up there with some third world countries. We're named on the WIPO list all the time for, you're not policing your borders and people are selling counterfeit goods into Canada. The government did introduce some legislation, Bill C-56, called the Combating Counterfeit Products Act, which would have made a number of changes and given some weapons to brand owners. But Bill 56 made it to second reading before Parliament was prorogued on September 13. So unfortunately, like many of the copyright bills that preceded the Copyright Modernization Act, this act died on the order paper, hopefully to be revived. Let's talk about gripe sites. Basically sites where consumers who aren't fans of certain brands or marks express their discontent by either registering a domain name that expresses their displeasure, or have their own site that might not have the brand in it, but the content is not very favorable. They're basically going after these brands. So there's some jurisprudence in the U.S. involving gripe sites, not too much yet here in Canada, where disgruntled gripers register web domains to criticize a company. So typical examples are companyx.com, companyxsucks.com, etc. So there are some cases in the States. There was the case, the Taubman case versus WebFeats. Now, Taubman was a retail developer known for creating, according to their website, extraordinary retail environments for shoppers, retailers, communities, and investors. So weren't too happy when someone started up the TaubmanSucks.com site. But Taubman lost because the court held there was no possibility of confusion and no Lanham Act violation, purely an exhibition of free speech. Another case, the Bosley Medical case, Bosley Medical Institute. They had BosleyMedical.com. Bosley was best known for their laser combs used to maintain healthy hair growth. I don't have that product in my cabinet. Again, they brought the action but lost. So there is some tolerance of the use of brands on Gripe Sites. Another pretty well-known site, Gripe site, pissedconsumer.com, allows users to post reviews of businesses with each business receiving its own web page and subdomain. So if you want to, yeah, okay, I'm supposed to end, but I think I'm going to go on for a couple more minutes. So go check out that site if you have a few minutes. It's really entertaining. There's a case where someone didn't really appreciate, Ascentive did not appreciate the fact that Opinion Corp had a pissed consumer site, and there the Eastern District Court of New York declined to grant an injunction to Ascentive as it was found there was no trademark infringement stemming from the complaint pages or subdomains, as there was no likelihood of confusion. And they noted, the court noted that pissed, in quotes, has entered the vernacular as a word instinct with criticism and negativity. Another one in the, there's a really good case in the UK. This guy did not like the airline Ryanair, so he registered a site called IHateRyanair.co.uk. And he gained some fame when the airline started proceedings to have Nominet, the registrar of the .uk domain, remove the owner's registration. Now, Nominet found in favor of Ryanair and transferred the domain to the airline, largely because the website made £322 from advertising links. So there's the commercial activity. So there was, if there had not been, if it wasn't a sponsored link site or a click-through site generating affiliate revenues, they probably would have lost. But they lost this case because of £322. So what happened was, after the transfer, the owner, and this happens a lot, transferred IHateRyanair to IHateRyanair.org. So the .co.uk went to, and so he started up IHateRyanair.org, and he referred to Ryanair as, and I'm quoting, the world's most hated airline and a bunch of filthy, thieving bastards. And after he moved to his website, here's how he greeted Ryanair. I'm just going to read this because I think it's funny. Ryanair, the world's most hated airline, have recently taken us to a Nominet domain name tribunal over the usage of the domain name for this website. Unfortunately, Lying Air won the dispute on a small technicality concerning £322 generated through affiliate deals, but never fear. We have already moved the site to its new home on IHateRyanair.org and will continue to provide you with all the latest on how this pathetic excuse for an airline will attempt to extract cash from you through sneaky hidden charges, fly you to places that are not where you actually want to go, and leave you stranded when the crap hits the fan. So there's a very important message here, and this is, as lawyers in the field, you have to give very practical advice. And the moral of this story is the legal response is not only the best one. So you pick a fight with a griper like this, and you get prepared for a massive PR battle, and one that you're going to probably lose. So I think that the uptake of that is sometimes let people gripe. We have clients, very high-profile brands. There are gripe sites out there. We tolerate them because, go ahead, you're never going to keep 100% of the people happy. You have to have some tolerance for that. So that's a perfect example of how that backfired. I'll wrap up. There are a whole bunch of interesting issues dealing with how people are using usernames and account names, parody accounts on Twitter. There have been some interesting cases there. Fan pages or inspired by pages. So that's all in there. I'll leave out the section about how you should respond, but I think that there are complaint procedures that you can use. So if your brand is up on any of these websites, I've found using the actual complaint procedures, sometimes co-opting. There's some really good examples of how brands have successfully collaborated with or co-opted with people and brought them in, gripers and fans alike, to their benefit. And I think that the legal response is not always the best one. Sometimes it's a communications response. Sometimes it's a non-response and tolerance, because sometimes a heavy-handed legal response will backfire in a big way. Thank you.
Okay, so we're a bit 10 minutes over. Those were excellent. If I could open up the floor for discussion, any comments, reactions, thoughts on what you've heard? Anyone else besides Professor Craig and David Baskin? Anyone else?
You got
Okay,
Stephen
yes,
there.
if you could come up. Yes, yeah.
Hi. Whoa. My name is Jason Rosenberg. You showed us a few examples of where the commercial aspect has been dealt with in jurisprudence in trademark law. Could you speak to how that might be able to inform our look at how the non-commercial aspect would be dealt with in copyright, and how, because I know typically trademark is dealt with a lot more formally and is often gone through the courts as opposed to copyright, which you get a cease and desist and then you shut it down. But so how can we use this jurisprudence that's there on commercial aspects and kind of transform it to copyright?
Great question, and I mean, hopefully we'll start to see as cases. It'll be interesting to see as cases on Section 29.21 come up, whether people will import some of the concepts and decisions on trademark law and how use and commerciality. You see from some of the cases that threshold's quite low, where the IHateRyanair case, the fact that the guy made 322 pounds was considered use. And was sort of a commercial activity sufficient to support an infringement claim. So I don't know if that's a really, that's a topic for a great paper, I think. How, use on the trademark side can inform the interpretation of Section 29.21. I'd be interested to see what my colleagues would say on that.
Yeah. Very, very good point.
Yeah. Okay. Yeah, I know.
I'd like to question Professor Trusso's interpretation of 29.21. And you correct me if I'm wrong, but my understanding is you suggested that there is a requirement of transformativity in the use of works in order for a use or prospective use to qualify for the exemption. In other words, you said it has to be transformative. That isn't present in cases of fair dealing. Do I have your point correctly?
There is a requirement of transformativity here. Yes, it's latent, but it's there.
As I read it, I don't see any requirement of transformativity.
Yeah, and that's the problem with just taking sort of a hyper-technical sort of textual analysis of a statute and not understanding its
I don't think
context.
I'm being hyper-technical.
Well,
by transformation, the word transformation implies the change of one thing to
Yeah.
another.
So can I explain why I think there's a transformational requirement here?
By all means.
Okay, so first of all, this is an exception to copyright infringement. So you don't even get into this unless you've used someone else's copyright work, okay? So we've got a situation where you're using someone else's work. There is a requirement right at the top about originality. You can't just, and this came up during the hearings on 2921, you can't just repost someone else's work. I used that silly example of a cat, but you can't just you just can't reuse someone else's work without adding enough originality to it that it meets the threshold. The term originality is a term of art under Canadian copyright law that has now been settled. So you can have entirely original work that's not transformative, like you create your own blog post without referring to something else, or you create your own statement without referring to something else. That's original, but it's not transformative. Here, it's necessarily transformative because if you're not substantially using someone else's copyrighted work, you wouldn't be talking about an exception to copyright. So when you read this in the entire context of what it means to be in Section 29 and what the use of the term of art original means in here, you put those two elements together, and unless you have engaged in some level of transformativity, this section is not even triggered.
No, I still don't agree. There can be originality in an anthology that consists of nothing more than a selection of works. The broadcast day, certainly by broadcasters, is thought to be protectable because it represents a unique assemblage of content over the course of a day. And similarly, if I create a mashup that merely sequentially places, let's say for the sake of argument, 4 pictures or 4 songs in a row, just simply one abutting the other without any kind of change or commentary thereon, it's hard to see how one transforms the other. But I think what you're saying to me is that by virtue of having composed a work which consists of subsidiary works, there is an inherent transformativity by virtue of the presence of multiple works.
You're actually underlying something that Daniel and I both emphasized, and that is you don't trigger this section unless you've met that requisite degree of originality. And you're quite right. Users who try to trigger this section without doing something besides just taking 2 pictures and putting them up. I mean, Dan didn't play 2 songs back to back and say, oh, I really like the way these 2 songs sort of fade into each other. He got under the hood of those 2 songs and put them together in very original ways.
But the fact that he did does not necessarily imply that sequential presentation wouldn't be original. The bottom line and the harm that this represents is that all kinds of people who perhaps are not as actively creative as Dan, or maybe more creative, it doesn't really matter, all kinds of people will say, well, there's an exemption, it applies to me. And the harm that it does is it creates a general impression that a giant hole has been carved out of copyright, and it's all free. And the majority of the people who comment in public, who aren't perhaps as educated as people in a panel like this, sorry, but the majority of people who interact with this legislation will perceive it as a free ticket. That's the harm that this does.
Well, that's what people have said about adding education to fair dealing too, and it's not a free ticket because you've got the 6 factors that you have to go through. Look, I understand why you're upset about this, and I understand why you're not supporting this, but I think what we have to do is realize that for the most part, people want to play fair. People do not want to infringe copyright unless there's a really good justification for doing it. And all this section does is stand as sort of a policy statement that we want to try moving into the direction of encouraging people, particularly youngsters, to sort of like be more creative with their use of social media.
Some people may have that motive. Some people just don't want to pay.
I'm not sure that, yeah.
Right. I just want people to know, and David, congratulations on your retirement, that this is the retired and mellow David Baskin. Imagine the still employed and revved up David Baskin.
I'm being mellow.
Yeah.
Someone at the back?
Yeah. You know.
I'll make it quick. I know everyone's hungry. My name is Sherelle Goodman, and I had a question. It was more directed at Professor Trusso. I know you as Professor, sorry. So Professor Trusso, but anyone at the table who can answer is great. It's with respect to 29.21. How would it interact with like like corporations or professionals? I'm thinking like the Star Wars corporation that's put out like a statement saying we'll allow these kinds of like fanfics and these kinds of story continuations, and they maintain like a website where they actually have everything as part of the canon. How does that work with 29.21
When the corporation, and I know there's going to be a panel this afternoon that's going to talk about fan fiction in more detail and those sort of derivatives, but when the corporation has the good sense right at the beginning to say, you know, go ahead and do this, then that sort of makes the resort to what's technically an infringement to copyright, an excuse for a copyright infringement, sort of besides the point, because the company is saying, yeah, go ahead and do that. We realize that we generate goodwill when you create user-generated content. So I don't think there's any. If I'm understanding your question, there's absolutely no conflict. It just, that type of corporate behavior makes the need to resort to technical legal rules less necessary.
So something was like it kind of wasn't specified there, but then it could potentially fall here because they have like an explicit statement. Like what they've like said, we will allow or won't allow this section wouldn't necessarily protect that gray area.
If you have the consent of the copyright owner, then you don't even have a technical infringement. and I read that as giving some broad consent. You can do things that take you out of that consent that might annoy the copyright owner to the point where they say, no, you've gone way beyond my consent, and now you've got prima facie case of infringement. Then at that point, you have to deal with fair dealing or 2921. But I think as a matter of corporate policy, that is an excellent way of dispute resolution.
Okay, so it's time to thank the speakers. I have to say there was a lot discussed, and the discussion will continue. We have many panels to follow, particularly one on business models, and I think some of the themes that came up, you were talking about, Len, the legal response, and I think, or another appropriate response, and that's a great one to look at UGC. Sam, you mentioned about the sliding scale in terms of commercial use and whether something is commercial or non, and we should be creative and think of perhaps allocation mechanisms. So why don't we look forward to discussion that continues. It's lunchtime now. Thank you so much for that. Let's all enjoy some lunch.